Okay, sir.
Yeah.
The host will open first.
Yes, but I thought so. So I was just wanting to make sure.
Okay.
Okay. Good morning, ladies and gentlemen, to the Honorable Dr. Trilaksmi Indreswari SH, Vice Dean of Faculty of Law, Universitas Diponegoro, the Honorable our visiting lecturer for today, Professor Dan Svantesson, LL.B, LL.M, P.hD from the Faculty of Law, Bond University, Australia. A very warm welcome we bid to all of the participants and the students of the Faculty of Law, Universitas Diponegoro. I would like to express our heartfelt gratitude for your presence at this memorable occasion. It is indeed a pleasure to have you all here today. We thank God for his blessings that this morning we could gather here together in this general lecture regarding cross-border legal issues and the internet. Before we begin, please allow me to read the agenda of the session this morning. First, we will hear a welcoming speech from our Vice Dean of Faculty of Law, Dr. Trilaksmi Indreswari. And second, the lecture will be opened by the moderator, Mrs. Sartikananda. And third, the presentation will be delivered by our guest lecturer, Professor Dan Svantesson. And finally, at the end of the session, there will be a question and answer session and a brief photo session. Ladies and gentlemen, without further ado, we will now listen to the welcoming speech delivered by the Vice Dean of Faculty of Law, Universitas Diponegoro, Dr. Trilaksmi Indreswari, SIMH. The time is yours.
Yeah, okay. The Honorable Professor Dan Svantesson, LL.B, LL.M, P.hD from Faculty of Law, Bond University, Australia. The student, lecturer, all participants, greeting to all of you. Good morning. On behalf of Faculty of Law, Universitas Diponegoro, it is a big honor for me as a Vice Dean for Academic Matters to welcome our special guest, Prof. Dan Svantesson from Bond University, Australia, and all participants for joining the visiting lecture today. We would like to express our heartfelt and highly appreciation for Professor Dan Svantesson for accepting our visiting lecture invitation. Thank you, Prof.
Thank you.
We do hope you can visit us, Faculty of Law, Universitas Diponegoro, in future, physically, not in virtual. Yeah. Today, the theme of visiting lecture, cross-border legal issue for the internet. Personally, I hope the visiting lecture today would give significant implication in our education and especially in development of our student quality. We do hope the collaboration and networking between Faculty of Law, Bond University, Australia, and Faculty of Law, Universitas Diponegoro can be implemented continuously in the future. To all participants, thank you for joining this program. Enjoy the visiting lecture. Thank you.
Thank you very much, Dr. Trilaksmi Indreswari, for the speech. Ladies and gentlemen, before we start the session, I would like to introduce our moderator. Our moderator this morning is Mrs. Sartikananda Lestari, SIMH, LL.M. She received her bachelor's degree in Universitas Diponegoro, her master's degree in the National University of Malaysia and Universitas Diponegoro. Currently, Mrs. Nanda is a lecturer here at the Faculty of Law, teaching business law, intellectual property, and also company law. Mrs. Nanda, the platform is yours.
Okay, thank you very much, Daniel. Good morning or good afternoon for Professor Svantesson. I would like to say welcome to our honorable speaker, Professor Dan Svantesson from Bond University, Australia, our Honorable Vice Dean for Academic, Dr. Trilaksmi Indreswari, and also our distinguished participants. Thank you very much for finding time and joining today's lecture. Our topics today is cross-border legal issues for internet. My name is Sartikananda Lestari from Business Law Department as the moderator for today's lecture. Okay, before we start, let me explain some information. First, this session will last for 50 minutes, 30 minutes for delivering the lecture, and 20 minutes for question and answer session. Second, if you have any question for the speaker, please use the chat feature on the platform or raise hand feature for speaker to answer after the session. Third, this session is recorded and broadcasted live in our official YouTube. So please be aware, if you have your microphone on, make sure to turn it off. Okay, ladies and gentlemen, now we can begin. For those who want to know more about legal issues and internet, Professor Svantesson here to enlighten us regarding this topic. But first, I will read his curriculum vitae. Professor Svantesson is a co-director of the Center for Commercial Law at the Faculty of Law, Bonn University, and a researcher at the Swedish Law and Informatics Research Institute, Stockholm University. He specializes in international aspects of the IT society. Professor Svantesson also published a range of books and articles and given presentations in Australia, Asia, North America, and Europe. Professor Svantesson also have professional admissions, such as International Law Association's Committee on Intellectual Property and Private International Law, and Panel of Experts for the Internet and Jurisdiction Project. And I believe there is still many professional admissions that Professor Svantesson have. Okay, without further ado, time is yours, Professor, for delivering the lecture. Thank you.
Thank you so very much. Thanks for the kind welcomes from everyone. And thank you all who have taken the time to listen to me today. I normally start with this slide here. You can all see my slides, I think, to sort of highlight a few things. I put this slide up to show my university and also the Gold Coast where I live, but also the pictures here, they depict a character from an Australian movie, Crocodile Dundee, and also the chef from the Muppet Show, the Swedish chef from the Muppet Show. Why do I put this up? Well, the Crocodile Dundee from the movie is very difficult to understand due to the Australian accent sometimes. And the chef from the Muppet Show, the Swedish chef, is almost impossible to understand. And I, unfortunately for you, have both the Swedish accent and the Australian accent a bit. So perhaps it might be a little bit difficult sometimes to hear what I say. And because there's so much I want to tell you, I might also end up speaking rather quickly. What I want to say is this. If there's anything I say that you didn't understand or want me to repeat or something, please just let me know. The point here is to make sure that I communicate as clearly as possible with you, despite my perhaps strange combination of different accents. Right. There is, I'm also then happy to follow this format of 30 minutes for the talk and then 20 minutes for the questions, if that was how it was preferred to be done. I have a lot of things that I would like to speak to you about. This is an area that interests me greatly, so I can only touch upon a few subjects, but that doesn't mean that we can't talk about other things in the question time too. So feel free to bring up anything within the sort of cross-border legal issues in relation to the internet, because it's all within what I work with. Sometimes I start to illustrate, in a sense, what the problem online is. I start with an imaginary scenario. If you imagine that you think that my lecture is very boring and you go onto social media and write something mean or maybe even defamatory about me and saying that I am a bad teacher and saying useless things and so on. Which country's laws should you then consider to make sure that you're doing something that is lawful? Well, you are in Indonesia, I think, at least most of you. So Indonesian law would clearly be something that you would take account of. But that's not enough. Clearly, there's a cross-border setting here. I am in Australia and I work here and so forth. So you might have to take account of Australian law too. It's possible that I could sue here if it was I was defamed, for example. Then, as was highlighted, I am Swedish to start with. So I grown up in Sweden. I have a family in Sweden, and so on. Swedish law might very well be relevant too. And I give talks and have been teaching in a few different countries and published in places around the world. So there's another number of countries' laws that might be relevant based on where I have some form of prior reputation. Then, depending on what social media structure you're using, perhaps it's let's say it's Facebook or LinkedIn or something, then you might have to consider US law based on their agreement that I'm sure that you read very carefully, saying what you can and can't do on the relevant platform you're using. Clearly then, we already there have quite a lot of different laws that you need to take account of in doing something quite simple and mundane, such as posting something on social media. But it doesn't end there. Due to the nature of defamation law, how it works in most countries at least, you might have to take account of the laws of any place in which you have friends on Facebook or connections on LinkedIn or something where the content is being read. So to know which laws you need to take account of, you need to know where all your friends, let's call them friends, on social media are when they happen to read what you have posted, because it's the location where the defamatory content enters the mind of a third person. That is normally where you could sue, and the country's laws that might come into play as well. So it becomes already there almost, well, I would say it is impossible to know all the different laws that you have to follow when you're acting online. Then there is a matter of republications. You might be bound by the laws where your friends' friends are when they read a reposting of what you have written. So you can see the number of laws you are meant to follow explodes into great numbers. And we are then, as internet users, expected to follow all these laws that are perhaps contradictory even, and so forth. I have elsewhere described this as a situation of hyperregulation. We have so many laws applying to us at any instance. We can perhaps, rather than saying what law applies to me now, you can talk about a contextual legal system made up of all the laws that apply to you in the particular situation you're in. When making that online posting about me, maybe your contextual legal system was made up of 50 different laws, right? In another situation, if you're just sending an email to someone in New Zealand, perhaps, in which you were to defame me, maybe your contextual legal system for that particular activity would be limited to Indonesian law, New Zealand law, and maybe Australian law, something like that. So you can see that the number of laws you're exposed to are very much context dependent. But within that system, you would have to try to, if you want to be on the safe side, you have to try to identify all the laws. We already said that that would be very difficult. Then you need to try to access those laws. Let's say that it turns out that you need to follow the laws of Argentina. How many of you would know where to start in finding the laws of Argentina? It's not an easy challenge. I know that there is laws available from Argentina, freely available online, but it's not very easy to find if you're not familiar with the language and so on. And then even if you could access them, then you're going to have to try to understand these laws. And if they are in a foreign language, Spanish in the case of Argentina, it might be a big challenge. You can try to use things like Google Translate or something, but I would say it's rather risky to rely on the automatic translation tools when it comes to legal texts that lawyers often are not agreeing on. So there's the uncertainty there. And then, of course, you could have situations of contradictions in the law as well. One country's law might say that you are allowed to do something, and another country's law says you're not allowed to do that. In our example, it might be easy to adjust to the law that says you're not allowed to do it. But if you think about big multinational companies, they are very often in a position where one country's laws orders them to do something that another country's laws say they are not allowed to do it all. Those sort of contradictions cause serious problems. And all this uncertainty it's bad for internet users, but it's also bad for the efficiency of the law, of course. So I mentioned a Latin principle here. What about this Latin phrase? I'm not going to try to pronounce it because it never sounds good when I try to pronounce anything in Latin. But the meaning of a phrase is that ignorance of a law is not an excuse. It's a familiar principle applicable in most legal systems. We can see that that principle, in a sense, logical as it is and important as it is, it clashes quite clearly with the nature of our legal landscape online. Online, we cannot know all the laws we're meant to follow. At the same time, we have this principle saying that ignorance of a law is not an excuse. So you can see that the problem that I have highlighted actually has a very strong impact on something as fundamental as this ignorance principle. Some have suggested to me that all you need to do is to just follow the strictest rules and everything is fine. But how do we know which is the strictest rules? It's not like we can all say that Norwegian law is strictest on everything. It doesn't work like that. There is not one country that has the strictest laws on everything. So rather, to know what is the strictest rule, we would have to know the content of all the laws that might apply to us. And we're back in that problem. We cannot know that. So that doesn't quite work. I also expressed a bit of concern about the idea of always following the strictest rules, because if you imagine that you're doing something, you're posting some content online, doing so is legal in your country and legal in every country in the world, apart from in one country. If you follow the strictest rule then, the strictest country's laws, that would mean you can't post that content. But why should that country's duty be more important than the right to post that content given by all the other countries in the world? To me, that doesn't make sense, and we need to be a little bit careful with that as well, in my view. All right. So moving on, the internet is clearly then a big issue, and unfortunately in law, most lawyers still treat the internet side of things as a sort of side dish. The offline world is the main dish, it's the main thing they are concerned with, and then there's a little bit of attention to the online environment too. But that is not reflecting what society is like these days. All of you who's taken the time to understand the internet law side of things are doing something very important, because society now is so dependent on the internet side of things. We cannot continue treating the online as less important than offline. We need to start taking it very seriously. One example of that we can point to here then is there are some studies saying that Facebook have about 2.6 billion monthly active users. I've seen a figure of 2.3 billion too recently, but it doesn't matter. 2.3 or 2.6 billion is a lot of people. The most populous countries in the world, China and India, might have around 1.4 billion people or so on. What can we learn from that? Well, if China or India introduces a new law, it might apply to about 1.4 billion people. But if Facebook changes its terms of service that bind 2.6 billion people, then that impacts the behavior of 2.6 billion people. So in some ways, these companies, the rules they set are more influential than countries' laws are. And that causes problems for the companies, problems for the users, and problems for countries. We still have not worked out a good way to balance all that, the balance of powers involved there. That's something I'm not going to talk about much more right now, but it is certainly an important topic within this field. So there is, of course, a large number of internet users around the world, but it's an unfair world. There's a lot of inequality. Countries in our region have a lower uptake of internet than some other parts of the world and so on. So it's not even. There's, of course, progress everywhere, but we shouldn't forget that much work remains to make sure that the internet becomes an even more fair environment with equal opportunities for everyone. Now, there's some themes. I'm not going to, given the time, I'm not going to talk about all of this in equal detail. But if you think about this field that we're dealing with, I think there's at least 8 themes that are very important to keep in mind. Law struggles to keep up with technology. That's natural. Making laws, particularly making good laws, takes a long time. Making technology is much faster. So we're always going to have a lag by the law to catch up with technology. That's something we just have to accept, I think. What is less acceptable is that the legal profession struggles to keep up with technology. Lawyers, legal academics, judges, lawmakers need to, one way or another, ensure that they are sufficiently informed about the technology they are trying to work with, in the sense of making laws or rules around. That is very important, and all of you are, of course, part of the solution here by paying attention to this sort of materials. I always used to claim that our society is increasingly globalized, but then certain political developments have happened in the world and we've had a pandemic. So I would say maybe we're not saying the same degree of globalization anymore, but on the whole, societies are interlinked, not least via the internet, and that impacts how we can regulate the internet. What happens in one country will impact other countries, and we need to take account of that. Internet users have a dramatic growth patterns. That has been true for a long time, but with COVID and the pandemic that has hit us all hard, and I hope you all stayed safe in this, you could say that the online world has worked much better than the offline world. Without a good online world, we would have suffered even more under this terrible pandemic that is plaguing us. So the internet will certainly have advanced a lot. Internet usage, like what we're doing right now, has advanced a lot during this period, so it's becoming even more important. Now, I say that the online environment is international to a great extent. The point there is, even if you send an email within Australia, it might actually go internationally before it reaches its recipient and so on. Everything we do online typically has some sort of international dimension. And internet intermediaries like search engines or social media platforms or our video platforms and so on, they all play a very important role. And we are back at that theme then, that we need to find a good balance between what the internet platforms can do to regulate our conduct and what obligations are placed on them, what we realistically can expect from them. Technology competes with law as a regulatory force. I think this is a well-known theme for anyone who has looked at technology law, but going back to Lawrence Lessig and so on from the late 90s, there has been, for example, let's say file sharing. We can have laws against illegal file sharing and that might have some impact, but if you make it impossible to copy a certain file, then there will be no file sharing at all. So in that sense, technology as a regulatory mechanism is more effective than the law is. And that is an important thing to remember also when it comes to then how we regulate those who make the technology. Because we would like to see a sort of a lawful usage and so. Soft law competes with hard law. Hard law would be things like the normal laws that the legislator make. But if you, I know that there's discussions in Indonesia of data privacy laws, and of course everyone is then familiar with the European Union's general data protection regulation that has inspired a lot of movement in the world in that field. Now the GDPR, the General Data Protection Regulation, is a complex legal instrument, and that is the hard law. But because it's a complex legal instrument, there is bodies within Europe that issue guidelines and so on that becomes almost as important as the legal text itself. That is the soft law. This is not unique to the online environment, but it is quite an important feature of the online environment that soft law plays a very big role. So I think these are all important themes to keep in mind. Now, in 1919, or rather in 2019, I had the honor of publishing a report together with the Internet and Jurisdiction Policy Network that involved interviews with key stakeholders from governments, from academia, from big tech companies and so on, asking a set of questions. And they highlighted concerns about this whole cross-border dimension that we are talking about here today. And I wanted to bring attention to some things. One question we asked was, will cross-border legal challenges of the internet become increasingly acute in the next 3 years? And you can see there was a very strong majority saying that that will happen. So I think one thing to note here is things online from a legal perspective is getting more and more complicated. And we need to address these issues. One thing that I think was interesting in that context is that there was also the point made that we do not have the right institutions internationally to address these questions. And I think there is a bit of a siloing that happens. We have some organizations dealing just with trade issues. We have some organizations dealing with human rights issues. But I think like privacy, data protection is important both for trade and for human rights, of course. It is a human right, so it needs to be treated like that, but it also affects trade. But these siloing structures mean that there's not the right institutions to deal with those issues as a whole, in a holistic manner. It was also made a point that there is not enough international coordination in this area. And I think that is an important thing. Most times when we see problems online, we see each country react in its own way, and it is reactive rather than proactive. So laws come about often because something happened, the country responds, and they do so in their own way. That means that we have a more and more fragmented legal structure that companies have to follow. Those companies are active in more than one country. That makes it more and more complex to conduct business online, and that might be against what we should be striving for in some ways. And it also means that the regulation itself becomes less and less effective because it's so fragmented. So I think there are some things to work with in that. And perhaps the most important message I came across in writing that report was one of the participants saying this: the internet is neither the problem, nor is it the cause of the problem. The internet risks becoming the victim. So it's not the internet that is the problem here or cause of the problems. Rather, we need to think of the internet as an environment that we need to try to protect. And the internet, if we don't approach it as something that is worth protecting, we're not going to be able to keep the internet the way it is today. We're going to end up with something much more fragmented and ultimately less useful, I'm afraid. So there's some points that I wanted to mention on that. But so this is a sort of a negative message in some ways, but sometimes when I get a little bit depressed over how slow progress is, I think about this. We have gone away from these sort of statements. If you go back to the mid-90s and up to the early 2000s, there was a big debate about, should we regulate the internet at all? Does law apply to the internet at all? And I've taken up the most famous example of that debate is this Declaration of Independence of Cyberspace from 1996. It looks a little bit crazy, but a lot of academics argued these sort of thoughts too back then. But at least we've gone past that now. We are no longer arguing about should the law apply online. We know that it does, and that's important for everyone. So we have made progress over the years, but there's much that remains to be done. Some of you would be familiar with that the European Union's proposed Artificial Intelligence Act was released just a couple of weeks ago, or well, a month ago now, roughly, on the 21st of April. And I think it's a good illustration of how we're still trying to find our feet as to how exactly should a country go about regulating something that is so cross-border. The European Union has had great success with its general data protection regulation that I mentioned before, and now they're taking this initiative. What I've included here is Article 2 that outlines the regulation's scope in a geographical sense. And you can see that it is clearly impacting developers and so on outside the European Union. I think that is legitimate, but when we have situations where one country or region makes laws affecting foreign companies and actors' activities in foreign countries, I think the lawmakers in those situations need to do more to clearly articulate what in international law are they relying on as the legitimate basis for making that extraterritorial, if we want to use that word, claim. So there's some work that needs to be done in that regard. Now, there's a few slides that I'm going to skip, but I can, after today, I can send the slides to the organizers, and you can, if you would like, make them available to all the students for reference materials. But I will skip forward to a little bit. There is Australia's most famous case in the internet arena was this Dow Jones versus GoodNick, but it's an old case now, soon 20 years old, but it was an interesting case because it was the first instance where the highest court of a country dealt with cross-border internet defamation from a jurisdictional perspective. In the end, what happened, because I want to move on to the other topics I wanted to address too, but in the end, what happened was that the courts in Australia said that even though the publisher was overseas, the courts here could claim jurisdiction and the laws of Australia would apply. But that happened already then almost 20 years ago. So this is not new problems we're dealing with, but they are certainly important problems still. Let me skip forward because I had prepared for a different time frame than this, but half an hour is a good thing. One thing that was said in this GoodNick case was this. The courts wrote, however broad may be the reach of any particular means of communication, those who make information accessible by a particular method do so knowing of a reach their information may have. In particular, those who post the information on the World Wide Web do so knowing that the information they make available is available to all and sundry without geographic restrictions. I think this was very indicative of the times back then. There was an appetite for regulating internet activities. And the point here is, as soon as you put something online, you know it's going everywhere, so you should be prepared to be sued everywhere. I think it's way too simplistic, but we are very much these days in a similar mindset from courts and lawmakers. So I think there is some issues to work with there. Let me move forward to what I have been writing a lot about lately. What I think is one of the biggest challenges online is what I've described as the scope of jurisdiction. So what do I mean by that? Well, let's look at this. There is a famous quote from a book where the authors claim that with few exceptions, governments can use their coercive powers only within their borders and control offshore internet communications only by controlling local intermediaries, local assets, and local persons. I think we get a better, clearer picture of what goes on in the world if we remove the words only and read it without them. Then the quote would say, with few exceptions, governments can use their coercive powers within their borders and control offshore internet communications by controlling local intermediaries, local assets, and local persons. This is taking us in the direction of what I termed scope of jurisdiction. So you know that when we talk about jurisdiction in a traditional sense in private international law or conflict of laws, we would talk about personal jurisdiction. Do we have jurisdiction over the person in question? And does the court have subject matter jurisdiction? Does it have jurisdiction over that type of dispute? I think there is this third aspect of jurisdiction, what we can call scope of jurisdiction, namely, if a court can claim jurisdiction, how far in a geographical sense should their orders go? If they are ordering the blocking of certain content, should that apply? If an Australian court, for example, is ordering blocking of certain content, should it apply only within the particular state in Australia where it takes place? Should it be the whole of Australia? Should it be outside Australia as well? Should it perhaps be worldwide? That is the question of scope of jurisdiction. And that is becoming a very, very important topic lately. And I think we need to deal with it. Now, it has come up in many settings, and courts often take the view that it is more effective, of course, to block content on a global basis. So there was discussions when it comes to the so-called right to be forgotten, that's under the EU's General Data Protection Regulation. The idea was if we delist or block content globally, it is most effective. But then you can put that in any particular setting, and we end up with an internet where the only things that are available online are those that are lawful everywhere, and that's not so much in the end, actually. So the internet becomes less useful. So I think we need to be careful in this field. Courts, in my view, should not have a default position of blocking things globally or removing things globally, because it means that they decide for the whole world. As soon as we have a country deciding for the whole world, there's a lot of risks involved. Of course, global delisting and blocking orders and removal orders are fully legitimate in certain settings. Where, for example, child abuse materials and so on, normally no one would protest if you say that needs to be removed globally. But we can't have it as a default position for all types of contents that violate the rules somewhere. So global orders should not be the default position, and we can't have a one-size-fits-all type approach. So that's one of the things that I wanted to highlight. I have 3 more minutes, I think, according to my timekeeping. So the next thing I want to mention very, very briefly then is a matter of territoriality. So I understand that many of the students listening today are experts on international law. So you would be familiar with international law principles around jurisdiction. Often we trace them back to the so-called Harvard draft from 1935, the territoriality principle, nationality principle, and so forth. Of those, territoriality is, of course, often very much in focus. Territoriality is often seen as a jurisprudential backbone of jurisdictional claims. And you can see it also in the context of sovereignty. Also, when we talk about sovereignty, it also often falls back on a territoriality thinking. I've been a little bit skeptical of territoriality thinking for some time. I think the idea of distinguishing territorial versus extraterritorial in a binary sense is a bit too simplistic. It is like when we talk about the day, we can say we have day and we have night. That works for some purposes, but for some things, we need more granularity. When did I take this photo from my veranda? It was not day and not night, it was at dawn, right? So we have more granularity. In fact, when we're talking about time, we have a 24 hours of a clock and so on. It's not enough to have just day and night as a distinction. And it's the same when it comes to territorial, extraterritorial. It's too simplistic for most of our legal purposes to just have that distinction. Rather, I think it's a gradual thing. It's a matter of degree. So I have put forward a suggested jurisprudential framework for jurisdiction. So when it comes to claims of jurisdiction online, rather than focusing on territoriality, which is in the end a bad fit with a global internet, I suggested we should focus on these 3 principles. So I'm saying, in the absence of an obligation under international law to exercise jurisdiction, a state may only exercise jurisdiction where, number 1, there is a substantial connection between the matter and the state seeking to exercise jurisdiction. 2, the state seeking to exercise jurisdiction has a legitimate interest in the matter. And 3, the exercise of jurisdiction is reasonable given the balance between the state's legitimate interests and other interests. And those other interests can be things like the interest of other states, the interest of individuals under human rights law and so on, for example, or maybe even the interest of the global community and so on. So I'm not saying that territoriality shouldn't matter anymore. My point is just that that is not the jurisprudential core of jurisdiction. If I am driving on the roads of Indonesia and I drive too fast, then Indonesia clearly has a substantial connection and a legitimate interest in regulating that, and no other country have a stronger interest or anything. So that's territorially focused in a sense, but the principles I point to would be substantial connection and legitimate interest, not just bland territoriality or blunt territoriality. I can see that my time is up for the half an hour, so I just want to finish by saying thank you and to highlight some of my recent publications in this field, and I very much now look forward to discussing these things with you all. Thank you.
Okay, thank you very much, Professor Svantesson. I will highlight some point from your presentation. The first is about the famous Latin principle, ignorance of law is unexcused, and also the development of technology, especially internet, trigger people to rely on the online. And the issue is the user is not concerned about which law into force, which law should be obeyed, for instance, social media. And then some challenge arise, the situation, no geographical restriction, understanding the languages, the different policy regarding the law. Is it allowed to be applied or is not allowed to be applied? And based on that, the effectiveness of law become interesting to be discussed. And in his lecture, Professor Svantesson also point out that during this pandemic, the online world is grow faster and have important role, where the soft law have a big role too, not only the hard law. And then he also said that the most challenge in online world is about claiming the jurisdiction. How can state claim the jurisdiction within the country or the geographical restriction? And she suggests some points for that issue. I think that's the highlight for his lecture for today. And now we move on to the question and answer session. We already have one question, Prof, from Andy. Oh, okay, from Christina, from batch 2019, the second year student. I would like to ask, as you mentioned earlier that many laws from different jurisdictions may apply when using internet, when it comes to transnational legislation, which law comes to play? What are the jurisdiction rules? That's the first question, Prof.
Yes, there is a few different ways to look at that. If you actually end up before a court, the court will, of course, identify one applicable law, normally just one applicable law, and apply it, and the dispute will be determined based on that. And that's how we normally teach students private international law. We talk about which country could you be sued in and what law would be applied if you were sued there. But if you are an internet company, or if you are even someone like you and me posting something online occasionally, it's too, I suppose it's in some ways too simplistic to think like that, because it isn't just one country's law that might apply to you, because you cannot know where you might be sued. Because your activity might have an impact in many different countries, you, at least in theory, needs to take account of all those laws that you're exposed to. In the end, from a practical perspective, it becomes just an exercise of risk mitigation. You might think about, right, I wrote something rude about Dan. Where is it most likely he would sue? Well, he could sue here, there, and maybe a couple of countries, or and so on. And you try to look at those countries' laws and assess your risks based on those. It's not going to be just one country's law normally in the risk assessment phase. But once you get to court, of course, the court will normally identify one country's law. And there's still what is called a homewards trend, where most courts are still favoring, one way or another, applying their own country's law, because of course that is what they're most familiar with.
Okay, thank you, Prof. So the choice of the court is based on the parties, is it?
Well, partly. So if I were to sue here in Australia, then Australia's choice of law rules would determine, or let's say there's of course different states. So let's say I sue in the state of Queensland here in Australia, then the Queensland's choice of law rules would determine what is going to be the applicable substantive law. It might end up being Queensland law, but it could be Indonesian law, depending on the circumstances, or any other country's laws.
Okay, thank you, Prof. We move on to the next question from the fresh students from 2020 students, Brian Simon, asking about the data breach case from Indonesia. So yeah, recently we have the cases related to the healthcare database being sold to the online forum, to the other forum without any confirmation to us. And then the question is it possible for RAID, the forums that sold the database, is it possible for RAID forums, the platform where this data being sold, to be held accountable for this case or being forced to change their policy? Thank you.
Yes, thank you. There's, again, a very good question. The first question was very good, and this is a very good and both challenging questions too. So I congratulate you on that. So in this situation, there is two ways to think about it. Can Indonesia, one way or another, reach this platform based in the US? In some ways, it's going to be difficult. There is the possibility of taking action, sort of blocking the platform from Indonesia, which could perhaps minimize some of the negative implications. But in the end, there's not so much you can do in this setting in the absence of some sort of cooperation. This is of course a law enforcement matter, and there's a lot of work going on when it comes to how law enforcement, let's say in Indonesia, can get access to information held by a platform in the US and so on. In the US, the law is such that platforms can share certain data, normally what is called subscriber data, with foreign law enforcement without any restrictions in US law. Not all countries have that generous attitude to the platforms sharing. So it's difficult, and it's certainly an evolving area. In the end, there's something called mutual legal assistance treaties, under which law enforcement in Indonesia could turn to the US government and seek US government's assistance in getting the information they need to prosecute people here. But it is, as soon as it's in this sort of cross-border setting, it is very complicated, and it's a little bit unfair in that those doing bad things, like in this case, they are very often well protected due to the jurisdictional complications. But people doing the right thing are often very less well protected. One last thing I want to say about that data breach situation is I'm very much an advocate of data privacy and data privacy protection, but I also think it needs to be balanced. It needs to be upheld as a human right, but there's also scope for working with law enforcement to share information here, because what is law enforcement trying to do here is to actually protect people's privacy being affected by this leak. So there's two sides to that relationship between privacy and law enforcement activities.
Okay, thank you, Prof. And then we still have a lot of questions, and
Yes.
most of them is come from the fresh students 2020. It's also a question from Andi Chandra asking about how could the law implement. Oh, okay. If the data privacy law have already realized or enter into force internationally, how the law could control the society from each country on internet?
Let us see. Well, here's some. I'm not sure if I understood the question fully, but what has happened in the world a lot is, of course, we have had data protection laws going back many years, and they are now becoming more and more important in the same rate as data is becoming more important, of course. And the European Union has, through its general data protection regulation that I mentioned, had a great influence around the world. A lot of countries are modernizing their data protection laws to be on the same level or similar level to the EU, so that data transfers can happen between the countries. Often law reform in this field happens to make data privacy laws more compatible so that we can have cross-border data flows. We've also seen a lot of impact through big companies saying, well, the EU laws is quite strict. If we follow it, we're going to be complying with most requirements around the world. So we adopt that for all our practices. Does that answer the question? I'm not quite sure because there's many cases.
Yes, Prof. I think that's the question. That's the point of the question.
Thank you.
And then we move on to the Agnia Zara. There are two questions to you. The first, she talking about government is the law making body, has the right to make the laws. And then the question is, what if the laws that are related to the internet is actually going to violate the society's privacy and limit the rights of people to post something that they want? Since Indonesia, we are very sensitive, especially when it comes to defamation and cyberbullying. Maybe the first question.
Yes. I think governments has to be quite careful in how, obviously, like I said, I think it's a good thing that the law applies to the online environment. We don't want the internet to be a wild west where anything can happen. We have a dark web that is in that direction and we need to deal with that. At the same time, governments need to be very careful in how they approach internet regulation. And the protection of privacy is extremely important. It is important because it is a human right, but it's also important from a user perspective in the sense of without privacy, there cannot be any trust, I think. Privacy and trust have a complex relationship because if we have too much privacy, people don't know who they're dealing with and might lose trust partly too. But certainly we need to be very respectful of people's privacy, and it is a fundamental human right, and it applies equally online as it does offline. Absolutely.
Okay, maybe since Indonesia have a rich unwritten law, maybe it can be added to our regulation, or maybe can be a border for the people to do something. So we have the regulation, and also we have like a tradition, moral, and unwritten law that exists in Indonesia.
Yeah.
Okay, and then the second question from Agnia is, since the internet is borderless, in your opinion, does the law can create the borders that are needed in order to keep the internet a safe platform, considering you said that it takes a long time to make a good law?
Yes, that's again a very, very good question. In some ways, the internet is we talk about the internet being fragmented. It's fragmented in a technical sense, and it's fragmented in a legal sense. And this is what you're talking about in some ways. When each country has its own laws, that is the world we live in, right? In some ways, we need the internet to replicate that so that you can, with this scope of jurisdiction matter that I talked about, we don't want, if something is illegal in Australia, that doesn't mean that it can't be available anywhere else in the rest of the world, right? So we need the technology to be able to allow an order that blocks things for only Australia. Or if it's in the Indonesian court making order, maybe the default position is only blocking within Indonesia. And we have these technologies it's called geolocation technologies, have been around since the late 90s. And they allow whoever makes postings online, of course, can use these technologies to restrict where it can be accessed. We see it all the time with global platforms like some of the movie platforms and so on have different contents in different countries and so on. That's what we need to do. But we want to do that without losing the internet's global nature overall. So we don't want too much fragmentation either. It's a very fine balance that we need to always keep in mind when making decisions in relation to the internet.
Okay. We move on to the next question, Prof. We have a long question from Gifali Akmal. The question is about one of the advantages of internet over other methods of communication and commerce is that it enables access to a much wider, even a worldwide audience. Spatial distance and national borders are irrelevant to the creation and internet businesses, many of which are conceived to the express purpose of expanding sales horizon across borders. In a sense, a person can be anywhere in the world all at once. This ease of communication raises a vital legal regulation. However, when a person puts up a website on his home server and allows access to it from all points of the globe, does the subject himself to the governance of every law and rulemaker in the world? The question.
Yes. The simple answer, and this is the first time there was a question I can answer in one word, and that is yes. But is that a good situation? That's another matter, right? As soon as you put something online and it can be accessed everywhere, you are in effect exposing yourself to the laws all over the world. In some ways, the only reason the internet works as well as it does is that countries can't enforce those laws against you very effectively always, right? If every country very effectively could enforce their laws against anyone posting something online, we would end up in a situation where very few things can be online because it has to comply with all the laws in the whole world. Doesn't work so well. So while you are exposing yourself to the laws of all countries, really, at the same time, there is enforcement difficulties that work as a shield, and in a sense is the reason why we still can post things online without knowing the laws of all the countries in the world. Another good question. Thank you.
Okay, Prof. I think all the participants have a long question for you. It's a challenge for me to read. Okay, the next question has come from Rahandi, one of our lecturer.
Yes.
Some time ago, news circulated about the new WhatsApp policy, where the consumer data will be shared with third parties, especially Facebook. When there is data leakage of WhatsApp users due to data sharing activities between the affiliated companies concerned, who should be responsible for the loss of consumer data misissue? If the case occurs across countries, Indonesian WhatsApp users' data misused by Facebook, which have a different domicile, how to resolve dispute and which law apply?
Yes, partly it comes down to corporate structure issues. One useful illustration here was a famous case in the European Union. I talk a lot about the European Union, but in the data privacy setting, that is a particularly useful place to look to. There was a case where an action was taken against Google. Now, Google Spain, which was the local branch in question, does nothing really, or at least at that point, did very little but sell advertisement and so on. So the question was, could Google Inc., as it was at the time, the US branch, be responsible? There, the laws are such that it didn't matter where the parent company was and so on. You just focus on where the processing had taken place. And through that broad scope of applicable law as it was then, Google Inc. could be captured by that action. But in any given situation, you have to consider the corporate structure. So what is the relationship between the main branch and the parent company and so on? And also, how are the country in questions jurisdictional laws and choice of law rules shaped. Some are better equipped to deal with foreign defendants with that sort of corporate structure situation, and others are less so. It's always very complicated. There was a period where the big technology companies would meet every action by saying, well, we are based in a foreign country, so we are beyond your reach. That has met a lot of resistance, and I think we see that less and less now. I think these companies that are active in many countries have to acknowledge that they have a responsibility in many countries. So it's not possible to give a very straight answer as to which laws apply, because it would depend on the choice of law rules in Indonesia. But it's possible that you could take action against both the parent company and the subsidiary.
Okay, thank you, Prof. Yeah, the second question is still from Rahandi, asking about how are the right of to forgotten concept apply in Sweden and Australia?
Let's see. Within Yes, so the right to be forgotten is a very interesting thing, and it links into this scope of jurisdiction topic that I spoke on too. Put simply, for everyone who hasn't dealt with that so much before, the right to be forgotten is a right that says, well, it comes from the idea that once something is online, it is there forever. If something is in the old paper media, then it becomes old news very quickly and no one pays attention to it anymore. So the idea was we need some active steps to remove things that are no longer relevant. Delisting was a term that came about in that context. And in fact, this was the famous Google case I was talking about. What happened there was a Spanish man who every time you search for his name, certain information came up highlighting that he had had a bankruptcy earlier in his life. He asked that to be removed, but it stayed up. And in the end, the Court of Justice of the European Union decided that in such situations, there is a right to be forgotten. Roughly, it's not the best term for it, but that's how we often talk about it. Meaning that a search engine, if you use a search engine searching for a person's name specifically, then this sort of content should not be coming up. It is the same throughout Europe due to the harmonization of the rules. In Australia, there's discussions of whether or not there is a right to be forgotten. There is a privacy principle relating to that information about you should be accurate and up to date, which is very similar to a right to be forgotten. So arguably we have something similar here too. And I think many countries are going in this direction. The only thing I want to add to that is the problem is certain things, if a person has done something horrible earlier in their life, maybe you want to know that before you hire them or something like that. So there are legitimate reasons not to necessarily delete everything just because it's old, I guess.
Okay, thank you, Prof. We still have a question from the chat box from Retno Chatur. The question is, are border cross wrongdoings or crimes in the internet protected as a matter of international law? How far do or should states regulate the use of the internet? That's the first question.
Yeah, are cross or crimes in the internet protected as a matter of, well, I mean, crimes of various nature are crimes whether they are carried out online or offline. There's many important instruments that are made clear that, for example, human rights apply equally online. And of course, if just because you use the internet to commit a crime, it's equally much a crime as if you did the same thing offline. If you write something hateful against a minority or something online or in a newspaper, it normally would be treated the same. And the cross-border dimension to that just makes it more complicated often, but it doesn't change the law as it should be applied, I guess.
Okay, thank you very much. And then the second question is the cyber attack regulated under international law? In case there is a cyber attack conducted by another state, can it be conducted in a lawful way? And is there any international law regulating those actions?
Yes. it's a very complicated field. Good questions again. There are I can think you can say there's a great disagreement or not much agreement on clear rules for what amounts to a cyber attack, and how is it regulated under international law. One of the most advanced discussions of that is in something called the Tallinn Manual. There's something called Tallinn Manual 2.0, which is a NATO document talking a lot about international law applied in a cyber attack type setting. But this is very much an ongoing discussion. What can you do online that amounts to an armed attack and so on? We need a lot more work on those topics, absolutely. So good topic.
Okay, thank you very much, Prof. Those all the questions from the chat box. And then I think we have one from for direct question. It's come from Keisha Anissa. Hello, Keisha Anissa.
Hello, yes.
Yeah, you can drop your question.
Okay, good afternoon, the Honorable Professor Svantesson. First of all, I would like to say thank you for the comprehensive explanation towards this topic. So I would like to ask a pretty simple question actually regarding the community guidelines in each social media platforms. So in each social media, they have their own community guidelines, which applies to the users regardless of their nationality. So where does that regulations in the community guidelines, or we can say the moral compasses, comes from? And what's the basis when we all have different sort of laws and customaries in each country? Does this have something to do with international law? Or and what if the user violates the community guidelines when it's something that is not restricted in their country or by the law of their country? Thank you in advance, Professor.
Thank you, Keisha. Those are very good questions, and they might be more complicated than you had intended. Number one, these community standards of the terms of service are in effect dealt with just as a contract, right? So you signing up to a particular platform, you click I agree or do something similar of that nature, and you enter into a contract, and therefore you're bound by these community standards. The relationship between those standards then and your country's laws is a very complex one, and I think that is a great question you raise there, and it's very much an unresolved issue. What is the relationship between the power of those terms that you agree to and your country's laws? Your country's laws might give you rights to do things that you're not allowed to do on the platform's rules, and the other way around. Much more work is needed in that sphere, and I think sometimes I feel countries take a little bit of a strange attitude to the platforms, because you very often hear countries say, these platforms have become too powerful. They can make decisions about content and they should not have that power. And then 2 minutes later, they say, these platforms are not doing enough to remove certain types of content and so on. We have a very difficult balance to strike there with when do we want the platforms to act as the filters for what can be online. Countries need to do more to produce clear rules around what the platforms are expected to do. One part of the problem here is that platforms might have millions and millions of pieces of content to assess very, very quickly, while at the same time a court might take a year to decide whether or not content A should have been allowed online or not. The platforms might have to make the decision within a couple of minutes. So things are bound to go wrong in some senses or some instances, and we need to then have a good approach to deal with that. But yes, I agree, there is certainly a big problem when we have community standards set by a foreign company, and they are set in one way. There are some variations sometimes, but generally set in one way, and they apply globally to users that come from many different countries with very different laws. So much work is needed in that field, and it's something that in the report that I mentioned, this global status report for the Internet and Jurisdiction Policy Network, I deal with those topics in some detail there, but definitely much more work is needed in that area. Thank you, Keisha.
Okay, that's a comprehensive answer, Prof. Thank you very much in advance.
Thank you. Sorry, I think you're muted.
Sorry, Prof. Sorry. Yeah, that's the last question from Efrema. And the question is about, you mentioned about the lack of international coordination. Do you think it would be better to create a single and separated international institution that deals with these specific issues, or should it be under the human rights institution? And
Yes.
will countries agree to comply with the regulation, or should countries be forced to comply? Thank you.
Yes, it is a very good question again. And in the question, you kind of also include what are the problems, because the problem is, of number one, countries will not agree. Countries might agree on the most basic things, like I said before, child abuse materials shouldn't be allowed anywhere. We can all agree on that. All countries can agree on that. But even there might be different definitions of what is a child and so on. So it's not as easy always as one would have hoped, perhaps. And we can't force countries. International law is not generally strong enough to force countries to such a structure. And in the end, it is tempting to have an idea of one institution governing the internet for the whole world. It could have huge benefits if it was done really, really well. But we are not going to get there in any time soon at all. It is possibly at this stage an impossible task, I would say. My suggestion for what we need to do is something called jurisdictional interoperability. There's other phrases around legal interoperability and so on too. The idea, from my perspective at least, is we need to, for each country, to be very mindful of the international nature of the internet as soon as they make a decision. If you can structure a new law in more than one way, and you can do it in a way that is less intrusive for other countries, then choose that path. By starting to iron out all the little differences between countries and start working on the bigger differences as well, we can gradually become more and more interoperable in a legal sense too, just like the technology is interoperable in a technical sense. And step by step, gradually, we can have fewer and fewer conflicts, and maybe in the long run that can lead to an international institution. But that is many, many steps ahead. But we need to do something in the meantime, and that's what I mean. We can take a very gradual approach.
Okay, thank you, Professor. Yeah, looks like Professor Svantesson already answered all the questions. There's a lot of questions from the participants here, and the questions, like a prof said, that it's challenging, interesting. Yeah, and
Yes.
I hope we can have another lecture from Professor Svantesson to dig deep more about the cross-border legal issues and also the internet. Okay,
I would be delighted.
Yeah, we also will. Okay, Professor Svantesson, is there anything else you would like to mention, maybe as the closing statement from you, Prof?
No, well, the one thing I want to say is I think that the questions you have asked have highlighted that this is things that people think about. It's not just a few professors sitting somewhere in an ivory tower thinking about these issues. These are real issues that affect our everyday situations, important issues, and I am so happy to have had this chance to meet you all and discuss these topics, and I wish you all the best, and please stay safe.
I mean, thank you very much, Professor Dan Svantesson. Okay, for all the participants and to all the speakers, I think that's all our lecture for today. Thank you very much to Professor Dan Svantesson and also to the participants. See you on the next times. Good afternoon. Assalamualaikum warahmatullahi wabarakatuh. Back to you,
Thank you.
MC.
Thank you very much, Mrs. Nanda, and Professor Dan for the great discussion. Ladies and gentlemen, and all of the participants, now we would like to hold a brief photo session. We welcome all of the participants to please turn on your cameras and take position. The photo will be taken on my signal. Please turn on your cameras. Okay, since there's no one else switching on their cameras, we're going to take the picture now. Ready? 1, 2, 3. One more. 1, 2, 3. Okay, thank you very much, ladies and gentlemen, and all of the participants. We have finally come to the end of our session. It has been a great and wonderful morning to the afternoon with all of you. Thank you very much for your participation and attention. Good afternoon.
Thank you, Professor.
Thank you,
Good
Professor.
afternoon. Thank you,
Thank you,
Prof.
Professor Dan.
Thank you,
Thank
Professor.
you. Thank you, everyone. Much appreciated to have the opportunity.
See you
Yeah.
again.
See you
Thank you.
again.
Bye.
Very great opportunity
Okay.
to discuss with you.